Hello, it's Phillip Taylor speaking from Richmond Green Chambers, and I'm looking at a book today from Waterside Press. It's called Fine Lines and Distinctions, Murder, Manslaughter and the Unlawful Taking of Human Life, and it's written by two people, Professor Terrence and Sir Blom-Cooper, Queen's Counsel, both of whom are highly experienced people in this very difficult, emotional and very serious area of law. We've given the book the title Calling for a Root and Branch Reform of the Law of Homicide. This is the book itself, 450 pages, relatively small index at the back, lots of footnotes, which is extremely useful to give us a bit more detail, an interesting cover, the getaway car in R versus Smith. There's some background information and quotes at the back, and I'm particularly drawn by the use of colour plates in the middle of the book, and black and white ones for that matter, which gives you an idea of the setting of the book itself. This has been really gone into in detail by the two authors. I attended the launch and I was impressed with the views made by the Lord Chief Justice, who's written the foreword, and I'll start off with that because in his foreword Lord Judge says, "I doubt whether any reader of this book will agree with everything in it." And I readily admit that although happy to write the foreword to such a stimulating and important work, I do not. And that the Lord Chief Justice himself should state unequivocally that he cannot agree with everything written in a book for which he has written the foreword is less dismaying than inspiring when you come to think of it. It exemplifies the tradition of fair comment, fair play and fair-minded debate, not to mention the almost universal acceptance in the United Kingdom of the principle of agreeing to disagree. Of course, that's where we are today with the future of the original Homicide Act and where we're going from here about dealing with this most heinous of crimes. So yes, the book is controversial, and on reading it you may not entirely agree with it either, although you may well agree with it in part, because the subject matter is murder, various kinds of murder, whether it's murder, manslaughter, or whatever, whether it's deliberate or accidental and the punishments, whether appropriate or inappropriate, and so on. And obviously the results are again important. One cannot get away from the passion expressed at the book launch and by the authors of the bad old days when we had capital punishment and all of the problems attendant to that. The title, Fine Lines and Distinctions, comes from the words echoed by Lady Wootton and Lord Parker when having the parliamentary debate on the abolition of the death penalty. And, of course, in its place what we have today is the mandatory life sentence for murder and all the attendant difficulties emanating from that decision. At least we've got rid of capital punishment. Now, following the years of copious research, analysis and professional experience by both of these eminent and distinguished authors, they agree that the English law of homicide is in a mess. Absolutely. So what's going to happen? Well, this book, I hope, will possibly be the start of some serious decision making by the parliamentarians, because that's where it rests, and they have yet to come up with anything that looks remotely sensible and will give a balanced amount of support from members of the general public. Forget about us as lawyers, it's the public who eventually you've got to carry on something of this nature. One is reminded on reading this book of the thorny issues raised in a number of cases in recent years, many of which are highlighted here, the very controversial ones in particular, and also reminded, of course, of current proposals to protect householders from prosecution, thinking specifically of the Tony Martin case, which we refer to in our written actual review of this subject. The problem today is, where do you draw the line between defending your home and actual criminal offences being committed by hitting someone or doing something to somebody which then leads to their death? That, of course, is the problem. This book, written in 2011 and published by Waterside Press, we think is timely, provocative and certainly topical, because it puts forward a closely argued and well-supported case for encouraging a root and branch reform of the law of homicide. I think it's attractive as a book, not just to judges or to practitioners, but to much wider audiences, criminologists and the general public, and I think that's probably why this has a much wider appeal. It's well written, but it's easy to read as well, which does help, because the problem is that the reform that we have must depend on legislation, obviously that is parliamentary time, and of course public support. Let me conclude by saying that the book is and therefore will provide ample evidence and ammunition to those who would agree that such a reform should be put in place as a matter of urgency, because we cannot, certainly in our view, continue with the indecision about the original Homicide Act and the need now to modernise again our approach to how we deal with this appalling crime. Thank you very much to the authors and to Waterside Press for an excellent, I hope, starter for a new debate in this area. Bye-bye.